All right, let's go ahead and get started. Hi, everyone. My name is Chris Guillen, and I'm a water and land use attorney at Brownstein Hyatt Farber Schreck. I'm also a member of the executive committee of the environmental law section of the California Lawyers Association. Thank you for joining us today in this second webinar in the Intro to Environmental Law series, co-hosted by the Environmental Law section and the California Young Lawyers Association. This webinar is going to cover Water Law 101. The first webinar in the series covered Air Quality 101, and that was a few weeks ago. The third webinar, roughly scheduled for the late September, will cover CYLA 101, and we'll conclude the series in early October with a webinar on how to navigate the Yosemite Conference, the Environmental Law Section's annual environmental conference, which is currently scheduled for October 14th to the 17th. This second slide is just a bit of information on the California Lawyers Association, the California Young Lawyers Association, and the Environmental Law section. CLA is the Bar Association for California Attorneys. CYLA is a part of CLA and is an organization for attorneys who have been practicing for 8 years or less. And the Environmental Law section is a group within CLA that focuses on the fields of law affecting the environment and environmental regulatory law. At the conclusion of this webinar, we will have a slide with more information on how to get involved with these organizations if you're interested. So here's our group of speakers today. We have Caitlin Haar from Chronic, Staley Prom from Surfrider, and Miles Hogan from the city of Ventura. Each of the presenters is going to talk a little bit about 101 level fundamentals of their water practice. Once that's done, they will each share a bit of an experience that they've had working on projects or cases in their practice. And then we'll talk briefly about opportunities for starting a career in water law, additional resources on water law, and ways to get involved in the CLA organization. And finally, we'll finish with a Q&A. So now I'm going to kick it over to Caitlin.
Thanks, Chris. Well, welcome everyone. My name is Caitlin Haar. I'm an associate at the Sacramento firm of Chronic, Moskowitz, Tiedemann, and Gerard. I am entering my third year of practice here on the Water and Natural Resources team. And just to give a little context background, I grew up in Shasta County around agriculture. So that's kind of where I discovered my interest in water issues, particularly in the agricultural industry. And I went to McGeorge School of Law to pursue particularly the water and environmental concentration there. Awesome faculty and coursework, which has only deepened my love for water. So I ended up spending my 2L summer here at Chronic Moskowitz, and I guess the rest is history. So just a little bit about kind of my journey to where I am today. Today, I'm going to provide just a very, I would say, general overview of California's water rights system. We could spend an entire hour alone just giving basics of California water rights. So there's a lot of nuances and distinctions that we won't get into today. But if you are interested and if you kind of enjoy this broad overview, encourage you to maybe take a water law class at your law school, or even seek out some of the awesome water industry events. We'll give you some resources at the very end of our presentation, and you can always feel free to reach out to the speakers and see how you can get more involved or learn more. So to get started, it's different from state to state, but California's water law system is what we call a hybrid system of water rights. And when we say a right, that we call that a usufructuary right, which means that rights holders have a right to use water, but it's a resource that's owned by the people and managed by the state of California for the people. So there are two main types of water rights that we'll talk about today. The first being surface water, and that's really kind of the water you can see flowing by in lakes, streams, rivers, that kind of thing. There are two main categories of surface water rights that we'll talk about. The first being riparian, the second being appropriative. And then the second main category of water rights that we'll discuss are groundwater rights. And that, for purposes of today, is basically everything that isn't surface water. And there are two types of groundwater rights that are pretty similar to the way we classify surface water. and those are overlying and appropriative. Next slide, please, Chris. Okay, so starting off with surface water rights. You'll see here, there's the photo at the top is actually a photo of the Fall River, which is in Shasta County, where I'm from. And this is a great example of riparian rights. So if you owned that land that you see along the river, then you may have a riparian right. So these are rights that you might have if you own land that's adjacent to a waterway. So your land directly touches that waterway. And there's no fixed quantity with riparian rights. These are, the concept is really reasonable use. And the way you use that is, we call it correlative. So you have kind of an equal share among other riparian users. And that correlative principle becomes particularly important in times of drought or shortage, because the idea is that you also kind of have an equal share of cutting back your use, or kind of an equal pain in times of drought there. A riparian right is a right to use the natural flow of the waterway. So it's not intended to be something where you maybe build a dam on a creek or a river to store that water up for long periods of time. And these are typically conveyed in a deed. So you would look to kind of the title, the paper that you obtained when you bought the land. And these are not typically lost for non-use. There's some exceptions, but you can learn more about those in maybe a water law course. So the next category of surface water is appropriative rights. And you'll see the picture on the bottom right hand of the screen. That is a picture of the California aqueduct. Great example of conveying water from the northern part of the state, kind of down through the Central Valley to the southern part of the state. And those are what we would call appropriative rights, where you are diverting water to use for a beneficial use. And these are typically, it's a fixed quantity of water. So you know you have X amount of water that you might be entitled to in your allocation. And the principle here is first in time, first in right. So that may be something you heard in your property law course as a 1L, where it's kind of, I was here first, and so therefore I have a senior right, and anyone that maybe moves in after or files a permit to use water after me has a more junior right to my right to surface water. And we have kind of two subcategories of appropriative rights. There are what we call pre-1914 rights. So those are kind of grandfathered in rights that were developed before California had implemented its kind of permitting system for surface water. And the second being post-1914 rights. And post-1914 means the predecessor to today's State Water Resources Control Board developed, once that was created, it developed a permitting system where you apply for a right and then you go through a process to eventually get a water right permit to use that. Okay, ready for next slide, Chris. Okay, so moving on to our second category of water rights, we have groundwater. And probably right now, the most appropriate place to start would be with what we call SGMA. So this is the Sustainable Groundwater Management Act of 2014. This is really one of the most significant water law updates that we've seen. So the purpose of SGMA is to provide a statewide framework to manage groundwater. And until 2014, there was no statewide approach. And it's notable that this was adopted in the midst of really the state's last historic drought, where we saw things like declining groundwater levels and people's wells going dry, needing to dig a deeper well in order to continue to pump and use groundwater. So those are some of the problems that you might see with overdraft of a groundwater basin, which means taking really more water out of the basin than is being replenished. So Sigma was implemented to, well, let me back up. Sigma requires local agencies to form groundwater sustainability agencies. We call those GSAs for the high and medium priority basins. And if you look to the map on the screen, this is the Department of Water Resources map of how they evaluated groundwater basins throughout the state to kind of determine the level of priority or urgency and the need to kind of address some of the overpumping issues. So the GSAs are charged with developing and implementing what we call GSPs, which are groundwater sustainability plans. And those plans are supposed to figure out at a local level how all of the groundwater users will avoid undesirable results and mitigate overdraft. And there's a lot of acronyms and buzzwords in Sigma. So we'll talk about maybe two of the most important ones now. The first being sustainable yield. And sustainable yield is kind of the goal that we're all aiming for. And that's looking at kind of the maximum quantity of water used kind of over a long period of time and what can be taken out and used without causing an undesirable result. So another buzzword there. And undesirable results, sometimes fondly referred to as the 6 deadly sins. A few of those include persistent lowering of groundwater levels, seawater intrusion, land subsidence, and there are a few others as well. So that's what we're trying to avoid by developing these GSPs or plans, and kind of the overarching, the local agency in charge would be your GSA. Okay, and then the last thing I'll mention here are basin designations. That's really, like I mentioned, you can see the map where they categorize really who needs to start working on their plans, their GSPs first, in order to more urgently work toward the goal of sustainable yield. Okay, Chris, next slide, whenever you have a chance. Okay, so the types of rights that you have within kind of the groundwater system. Overlying is very similar to the riparian right that we talked about for surface water. And this is basically where you have a landowner who pumps land, maybe with a well, and uses it on that overlying land that they own. Appropriative is similar to appropriative for surface water. And that's where you have someone who pumps water, takes that water and exports it, uses it elsewhere, maybe out of the basin. And the concept that really drives groundwater is reasonable amount for beneficial use. But again, we can't forget that Sigma is at play here. So a lot of that might be changing as local GSAs decide how they're going to reach that sustainable yield. And another important note here, that will likely, for many basins, look like a pretty significant cutback in pumping groundwater. So they've got to kind of figure out how they're going to allocate that cutback among users, which can be a tough, expensive, and tumultuous process. Okay, ready for the next. Oh, and I guess just to note here, sorry, Chris, on that last slide. You may have seen this photo on the right, which is an example of land subsidence, kind of a famous photo that was taken in the San Joaquin Valley. And subsidence is where the Earth's surface starts to sink or settle. One of the reasons this might happen is if you have a groundwater aquifer beneath the surface. If you're, taking water out of it, the aquifer might start to compact on itself. And this is one of the things that we're trying to avoid by applying the statewide framework of Sigma in order to kind of get a handle on that. And then on the left, you have just an example photo of an aquifer. Okay, ready for the next slide, Chris. All right, and just to mention a few water rights emerging trends, some things you might be learning more about or hearing about. Comprehensive groundwater adjudications. So a groundwater adjudication is generally where one water right holder will kind of sue everyone else that's in their local sub-basin or maybe a larger basin in order to go to court and have the court decide who has what right and maybe even the fixed quantity that they're entitled to under that right. And once CYLA was adopted in 2015, or in 2014, excuse me, in 2015, the kind of adjudication framework for groundwater was updated to try to make it consistent with CYLA and think about how those processes can maybe run parallel to each other or help each other. And I know Chris and Miles may have some experience with this, so if you guys want to chime in anything there, feel free. And I can go ahead and so we also have the public trust doctrine, and this is kind of a common law doctrine. The idea being that the state holds and maintains these natural resources that we have on behalf of the people in the state, and they have a duty to kind of protect and consider how their decisions or other decisions or projects of others may impact those public resources. So the public trust doctrine is something that we're seeing in water rights litigation more and more. So that's something to maybe be aware of and learn more. And the last being the human right to water. This is something that was actually codified in California's water code a few years ago. And the idea being that every human has the right to safe, clean, affordable, and accessible drinking water. And it's really yet to be seen how this will impact the existing system of California water rights, but it's something to keep an eye out for. And so with that, I will turn it over to Staley.
Awesome, thanks, Caitlin. Hi, everyone, I'm Staley, and as Chris said, I'm an attorney for the Surfrider Foundation. We're a national environmental nonprofit, and our mission is the protection and enjoyment of our ocean, waves, and beaches for all people through a powerful activist network. We're grassroots. We have 80 volunteer-led chapters around the US, including on the East Coast, Great Lakes, Gulf Coast, West Coast, and in Hawaii. And our 5 primary initiatives include clean water, as well as ocean protection, plastic pollution, coastal preservation, and beach access. So with our mission of both protection and enjoyment, Surfrider's clean water work focuses on protecting coastal water quality for safe recreation. And as part of this initiative, we have 2 clean water programs, our Blue Water Task Force, which is a citizen science water quality monitoring and notification program, and our Ocean Friendly Gardens program, which is an education, advocacy, and hands-on program implementing sustainable gardens to reduce stormwater runoff. In addition to these programs, our chapters engage in clean water campaigns related to things like holding industrial polluters and developers accountable, desal projects, and offshore drilling. And given the scope of our network, I've worked on clean water campaigns not just in California, but places like Puerto Rico, Lake Michigan, and Hawaii as well. And I'll be talking about some specific work examples later, but for now, I'm going to talk about the Clean Water Act, and specifically some aspects that NGOs like Surfrider and also governmental agencies may use in furtherance of protecting water quality and public health. So with that, next slide, please. So the Clean Water Act is the United States' premier federal law protecting water quality. We could talk about the act for hours, but with our limited time, I'm just going to focus on a couple of aspects in about 10 minutes. So the purpose of the act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. For some background, what we refer to as the Clean Water Act was originally enacted in 1948 as the Federal Water Pollution Control Act, but in 1972 it was significantly reorganized and amended and became more commonly referred to as the Clean Water Act. And an interesting note is an impetus for the 1972 Act was a river literally on fire. The Cuyahoga River in Cleveland, Ohio, that's pictured here, was one of the nation's most polluted waterways due to industrial pollution. And it was so polluted that it caught fire more than a dozen times between the 1860s and a fire in 1969 that drew significant national and media attention and is often credited as spurring calls for action and the adoption of the Clean Water Act. So now what does the Clean Water Act do? Next slide, please, Chris. Thank you. So the Act does several things, too much to discuss today, a few of which include: one, requiring that states adopt water quality standards subject to EPA approval and establish a framework for identifying and cleaning up polluted waters. Second, it provides states and authorized tribes authority to protect clean water from federally permitted activities under Section 401 with what's known as water quality certification. So there, the applicant must obtain certification from the state or tribe that its activity will comply with applicable water quality standards and policies. Third, the Clean Water Act establishes a program to regulate the discharge of dredge and fill material in U.S. waters under Section 404. And finally, one of the primary things that the Act does is prohibit the discharge of pollutants from point sources into navigable waters unless in compliance with a permit. And Section 402 establishes what's known as the National Pollutant Discharge Elimination System Permit Program, what are called NPDES or NPDES permits. And so now I'm going to break this last rule down a bit and talk about how some of these terms are defined, because there are certainly a lot of issues here. So first, these permits are required for discharges of pollutants from point sources. The Clean Water Act defines pollutant broadly to include several things, including dredged spoil, solid waste, sewage, garbage, sewage sludge, chemical and biological materials, radioactive materials, heat, and industrial, municipal, and agricultural waste, among others. Next, point sources are discrete conveyances, things like pipes and ditches. And then next, I'm going to talk about navigable waters for a minute. And this is a big issue since the Act covers and applies to navigable waters. These are defined in the Act as waters of the US, including territorial seas. And the definition of waters of the US, or WOTUS, as it's often called, is defined by regulations, therefore establishing the scope of the Clean Water Act's protections. And the definition of WOTUS has been a pretty contested issue for decades. Environmental NGOs like Surfrider, of course, believe in a robust definition that's in line with the Act's purpose of protecting the integrity of the nation's waterways, recognizing, of course, that waterways are connected within watersheds. What happens upstream affects downstream. What happens inland can affect coastal waters. And then meanwhile, industry lobbies for a narrow definition. I don't have a lot of time to get into details, but the US Supreme Court has addressed the definition of WOTUS in some of its cases. And in a nutshell, prior administrations have adopted differing regulatory definitions that have been subject to numerous lawsuits. Most recently in 2020, the Trump administration adopted the Navigable Waters Protection Rule, which the Biden administration and numerous NGOs view as reducing protections for a significant number of waterways and wetlands. It's been estimated that the rule eliminates protections for more than half of the nation's wetlands and around 20% of US streams. And in June of this year, the new administration's EPA and Department of Army announced their intent to initiate a new rulemaking process, redefining WOTUS to restore protections. And it was interesting to see the impact from the change in administrations earlier this year on related litigation as well. So in June, for instance, in one of the NGO coalition cases challenging the Navigable Waters Protection Rule, one of the EPA officials for the Office of Water, one of the new officials, submitted a declaration noting that the Biden administration's EPA and Army had substantial concerns with the lawfulness of the rule and its harmful impacts on the nation's waters. And then a recent update just this week on Tuesday, the US District Court for the District of Arizona actually vacated the Trump administration rule. The court's opinion said that this wasn't a case where EPA could adopt the same rule on remand with better reasoning or procedural rules. And the court held that not vacating the rule would risk serious environmental harm. So in summary, the definition of WOTUS, establishing the whole scope of the Clean Water Act, is a very important issue, and stay tuned for a new WOTUS rulemaking. And then finally on this slide, with respect to enforcement, EPA or states authorized to carry out NPDES permits can bring clean water enforcement actions for violations. And violations may include, for example, discharges that exceed a permit's pollutant limits or discharging pollutants without a permit. And where EPA or an authorized state is not diligently prosecuting a violation, the Act provides that interested persons may bring citizen suits. And later today, I'll talk about an example where Surfrider has brought a citizen suit under the Clean Water Act. So that is a very brief summary of the Clean Water Act. Next slide, please. And now I'm going to touch very briefly on a 2000 amendment to the Clean Water Act, the Beaches and Environmental Assessment and Coastal Health Act, or BEACH Act. So this act is significant for protecting the public health of anyone who wants to enjoy a day at the beach and not worry about getting sick because of polluted water. The act established a federal grant program for states, territories, tribes, and local governments to implement and carry out water quality monitoring and notification programs for coastal recreation waters. And the EPA has issued guidelines on how grant recipients carry out their programs and provide the required notification. This generally includes identifying beaches both based on the presented risk of pollution and also public use of a beach, which are then tested for bacteria, and then providing public notification by way of signs at the beach if there is pollution. And these programs are very important for protecting the health of recreational users at beaches. If some of you are tuning in from the LA area, you may have heard about the recent Hyperion sewage treatment plant spills of millions of gallons of raw and untreated sewage, raw or partially treated sewage into the Santa Monica Bay. I actually first learned of the spill when I was at the beach and luckily saw a warning sign posted, so I knew not to get in the water or let my son play in the water, illustrating just how important signage is when there are pollution concerns. And Surfrider advocated for the initial passage of the beach bill, and we advocate for continued funding each year, which is really critical to allow for and supplement state and local testing. And so that is the Clean Water Act and Beach Act in a nutshell. And of course, there are a lot of water quality issues and emerging concerns that I haven't covered, like plastic pollution in our ocean and ocean acidification. But I know that there will be at least a couple of water-related panels at the Yosemite Conference, so I encourage you all to attend and check those out. And now I'll turn things over to Miles to discuss water law from the municipality's perspective.
Thank you, Staley. And I just wanted to mention briefly, we're going to try to save 5 to 10 minutes at the end to answer your questions. So feel free to type those into the chat and Chris will monitor those and hopefully we can get to those in the last few minutes. My name is Miles Hogan. I'm on the executive committee for the environmental law section. And I used to be on the executive committee for the California Young Lawyers Association. So if you have any questions about those sections, I'm happy to answer them, but I encourage you to get involved. So I am going to give some perspective on legal counsel for water service providers in the state. I went to UC Davis for law school and studied public interest environmental law. In college, I studied marine biology, so I've had a long interest in water. And after law school, I did a fellowship for a year and then worked at a private law firm for a few years representing public agencies in water and wastewater law, and then came to the city of Ventura about 5 years ago. So here on the slide, there's a few examples of water service providers in the state. So there's privately owned water companies such as California American Water, Golden State Water Company, and then there's also mutual water companies. And these are regulated by the California Public Utilities Commission. There's also public water suppliers in the state, such as cities like the city of Ventura that I work for, or the Los Angeles Department of Water and Power. There's also county waterworks districts, municipal water districts, community services districts. And then wholesale water providers are public agencies that deliver water to what are referred to as retail water providers that actually serve the water to customers. And these are regulated by the State Water Resources Control Board and its Division of Drinking Water. and the 9 regional water quality control boards throughout the state. The next slide. So I'm going to highlight a few things quickly about water supply planning and regulation. So first, there are urban water management plans that certain urban water suppliers have to prepare and adopt every 5 years. They are long-term resource planning documents to ensure that adequate water supplies are available to meet existing and future water needs. A few of the requirements are listed here on the slide of what they need to contain. And the requirements are included in the California Water Code. And then the Department of Water Resources also puts out a guidebook every 5 years on what to assist agencies in updating their urban water management plans. In my role as the water attorney for the city, I help advise them to make sure they're complying with all the requirements. I participate in water commission and city council meetings when they consider adopting the plan, and then help write the resolution to adopt the plan. Next slide. Here are some other water supply planning and regulation items I just wanted to mention. So there's water shortage contingency plans that also need to be updated every 5 years as part of the urban water management plan process. There's also water shortage regulations that agencies adopt when there's a shortage in the area served by the water district or water agency. They include 6 stages that call for additional cutbacks as supplies decrease relative to demands. And there's some requirements listed out there from the California Water Code. There's also the Model Water Efficient Landscape Ordinance, or MWELO. That governs landscaping for new development or retrofitting landscape to meet certain water efficiency standards. And agencies are required to report to the Department of Water Resources on compliance with that regulation. There's also water conservation regulations that agencies adopt, and new legislation was passed in 2018 that establishes conservation as a California way of life and will impose additional requirements on agencies to meet certain performance metrics on the amount of water that is used by customers and by the agency at large. We also work on long-term planning and capital improvement programs. So things like replacing pipelines, wells, treatment plant components, looking at new supply sources, and ensuring there's adequate water quality in the system for customers. There's also issues related to development. So these 2 bills were passed in the early 2000s and require water supply assessments for certain projects, as well as water supply verification letters for certain projects. And this is a really interesting area right now as the state seeks to address the affordable housing crisis in California, while also agencies need to ensure there's sufficient water supply to serve these new housing projects that are getting approved. Next slide. Let's see, I'm just checking the time. So I'll briefly cover water rates. So agencies, of course, need to collect water rates to make sure they have sufficient. And I'm just going to answer this question now. There's a question, will the slides be available or distributed to attendees? Yes, the CLA staff will email it out to all attendees. So just wanted to, you'll have this after the fact. So for water rates, they are governed by a provision in the California Constitution known as Proposition 218, which sets out procedural and substantive requirements for adopting municipal water rates. So procedurally, the agency needs to identify the parcels subject to the charge and calculate the amount of charge to be imposed on the parcel. You have to provide written notice to all record owners of the parcel where the charge is going to be imposed with certain requirements of what's in that notice. And then you have to hold a public hearing no less than 45 days after the mailing of that notice. You consider all the protests received, and if a majority of owners protest the charge, the agency cannot increase the adopt the increased water rates. Next slide. There's also substantive requirements to adopting water rates under Proposition 218. I'm just going to highlight that the amount of the fee charged on any individual parcel cannot exceed the proportional cost of providing service to that parcel. So there have been many cases on this issue and the substantive requirements on meeting that requirement. The way I like to describe it over on the right side of the screen is the task is to set rates proportional to the cost of providing all services allocated reasonably amongst group ratepayers based on a cost of service study utilizing reliable data. So you would want to work with a financial professional to take agency data, develop a detailed cost of service study report, and that forms the administrative record to support the increases in rates. And I think I'll go move to the next slide in the interest of time. I also briefly want to mention water service and customer protections. So in 2018, the Water Shutoff Protection Act was passed via Senate Bill 998. It requires certain procedures for agencies to follow before they can discontinue a customer's water service due to non-payment. And there's more information at the link there. And then of course, right now, many customers are struggling under the COVID-19 pandemic with paying their water bills. They may have lost their job due to the shutdowns. The governor issued an executive order last year suspending public water systems' ability to disconnect water service to residences and critical infrastructure sector small businesses. However, that executive order will expire at the end of this month, and the State Water Board is working on a California water and wastewater arrearage payment program. There's a link there for additional information, but the basic idea is they will use federal relief funding to forgive debt accrued by agencies during the shutdowns up until June 15th. And then the agency would then forgive that debt to the customer. And so this program is in development, and I encourage everyone to keep checking that website for updates. Next slide. And now I'll turn it back to Caitlin to go over some work examples.
Great, thank you, Miles. So one example of the services that my firm or a private firm might offer to various types of clients is to conduct a due diligence water rights analysis. So what does this look like, and who would want one, and why would they want one? So to start, a few types of potential clients could be landowners, developers, or maybe farmers and ranchers. So a landowner, particularly in the current climate with drought conditions, might realize that they're limited in supply, or maybe they are worried they might get into a dispute with a neighbor about how much water they're entitled to use. So they come to us and ask, can you evaluate my water right and the strength of that water right, and maybe even how much water I am entitled to, depending on the type of right that they might have. A developer might be interested in, that's one of the most important aspects of development, is that they can show that they have adequate water supply to support the project that they're developing. So they might come to us and say, can you please explore this, because you have water expertise, and we want to make sure that we evaluate this fully before we move forward with a significant investment. Same with farmers and ranchers, particularly again in times of drought, wanting to know so they can plan maybe what crops to plant, or if they need to take out some more water intensive crops. They want to know what rights they have, the strength of that right, and sometimes to be prepared if there are any potential challenges that might be brought against them or their right. So those are some examples of who might want this. This type of work could be done really for any type of water right. We talked about surface water rights and groundwater rights. I'm going to talk specifically just about a riparian analysis, which is type of surface right where you have property that is adjacent to or contiguous to a waterway. So what does this process look like to determine the existence of a right and the strength of that right? So first you'd start by obtaining what we call the chain of title, which is basically this big stack of either digital or physical papers where it documents all of the land, all of the transactions of that particular parcel of land. And this usually goes back to a patent where the US government, maybe in the mid 1800s, conveyed or transferred ownership of that land to an individual or a person. So you're looking at sometimes these really antiquated old cursive, scrolly cursive documents, and then reading each document forward to figure out, to piece together kind of the story of the property and what has gone on. And so you're tracing these conveyances. You start at go back to the very beginning, and you trace it forward to present day. And so what are we looking for when we do this? You're looking for what we call severance, which is maybe where the land has been subdivided or sold in a way that one parcel is no longer touching the river anymore. So that would be one way that you could potentially lose your riparian right. Other things of interest, we're looking for gaps in the title chain, which basically means, in your stack of documents, there might be something missing, a time period where there are no records of who owned the land or maybe what they were using it for. So it's very interesting. If you like history, this would also be a great task for you, because there's a lot of thinking outside the box and, what was going on in this local area at the time, or in the county, or maybe even in the country. If you look at a title chain in the 1930s or that time period, you might see a lot of land under bank ownership. Think about, maybe that's because the Great Depression was going on. So you get to think a little bit more broadly and also kind of be creative. You might work with a historian to do this kind of work, maybe even some more technical experts, hydrologists, to figure out what you have available. So that's just a little bit about a due diligence water rights analysis. Happy to answer any questions in the chat box if you all have any. I'll turn it over to Staley.
Awesome, thank you, Caitlin. So I'm going to discuss one of Surfrider's ongoing Clean Water Act cases, and it actually involves surfing in this region shown here. And you may be surprised to learn that this is not an ocean wave, but it's actually a surfer in northern Indiana at the south end of Lake Michigan. And in 2018, on behalf of our Surfrider Chicago chapter, we filed a Clean Water Act citizen suit against the steel manufacturer US Steel after their facility on the south end of Lake Michigan spilled nearly 300 pounds of toxic hexavalent chromium into a waterway that empties directly into the lake. And they had also had numerous other continuing violations. So, and as you may be able to gather from the smokestacks in the background of this photo, the South End is a heavily industrialized region, and it's also home to some of the Great Lakes best surf. And the spill happened right next to one of the area's most popular surf spots, and the Indiana Dunes National Park, where many of Surfrider's members surf and recreate. And hexavalent chromium is a highly toxic compound that can have serious impacts on human health. And if you've seen Aaron Brockovich, we're familiar with that story. That was also the toxic chemical at issue there. So a few months after Surfrider filed our lawsuit, the US and Indiana Department of Environmental Management also filed suit. So our separate case was stayed or put on pause by the court. Then we intervened, meaning we joined the government's case, joined as a party. And the city of Chicago actually followed Surfrider's lead in filing suit and is also an intervener in that case as well. And when the governments filed their complaint at the same time, they also proposed a consent decree for the court's approval, which is a type of settlement agreement that was entered into with US Steel. Surfrider, we opposed that consent decree because we believed that higher penalties were warranted and that also additional improvements could have been made or required. The consent decree was revised after a public comment period, with US Steel agreeing to implement a local environmentally beneficial water quality monitoring project and also to improve their public notification requirements in the event of future violations. Surfrider did continue calling for additional improvements to the consent decree, but unfortunately just earlier this week, the court approved it. And while that was certainly disappointing, particularly in light of continuing violations by US Steel, even after they're purportedly adhering to the consent decree, the court did recognize Surfrider's efforts, which resulted in meaningful improvements to the agreement as initially proposed. So given that our separate case is still pending and the matter is ongoing, I can't share much more, but we are continuing to review that recent opinion and consider next steps. And I'll also add that Surfrider, when we engage in outside litigation, or when we engage in litigation, we work with outside counsel. So here we're generously represented by the University of Chicago Law School's Abrams Environmental Law Clinic. And we do have several blogs on, blog posts on our coastal blog post, on Surfrider's coastal legal blog, if you're interested in learning more. And on the next slide, please, I'm also going to briefly touch on another case that you may have heard about. So Surfrider was also recently a plaintiff in another Clean Water Act lawsuit, the Hawaii Wildlife Fund versus County of Maui case. And there, represented by Earth Justice, we sued the county for discharging 3 to 5 million gallons per day of treated wastewater into injection wells. The water is injected into Hawaii's groundwater and then quickly reaches the nearby Pacific Ocean. And it's been really harmful to a nearby beach park that's popular with snorkeling and surfing. And the county's been doing all of this without an NPDES permit. So Surfrider and our co-plaintiffs, we won at the District Court and Ninth Circuit Court of Appeals, and then the county appealed to the US Supreme Court. And in a high-profile April 2020 decision, the US Supreme Court held that the statute requires a permit both when there's a direct discharge from a point source into a navigable waterway, or also when there's the functional equivalent of a direct discharge, and it created a functional equivalency test. So just real quickly, depending on the circumstances, factors considered under the test may include things like the transit time, the distance a pollutant travels, the nature of the material through which it travels, and a lot more. The court did say that time and distance are going to be the most important factors in most cases. And as a recent update, the case was remanded back to the US District Court in Hawaii to apply the new test. And just a few weeks ago in July, the court once again ruled for Surfrider and our co-plaintiffs, holding that Maui County is required to get an NPDES permit. So a really great victory there. Surfrider also has a recent blog post on this case with a link to the court's decision. If anyone's interested in learning more, and I'm happy to post that in the chat also. So thanks, and I'll turn now to Miles.
All right, I'm just going to discuss 2 brief work examples to give attendees an idea of things you can work on once you're a water attorney. So here, one example, the city is working on a potable reuse project. On this image, you can see our wastewater treatment plant, the Ventura Water Reclamation Facility. It tertiary treats its water and discharges it into the Santa Clara River estuary. The city was sued over concerns about the volume of water and the quality of water being discharged into the estuary, and entered into a consent decree with 2 environmental organizations. over that. Next slide. These are some of the species, the sensitive species in the estuary. So the Southern California steelhead, the tidewater goby, the Western snowy plover, and the California least tern. Next slide. So the city was required to study and evaluate the appropriate amount of water to discharge to the estuary and then divert the rest to a beneficial reuse. So the Ventura Water Pier program is a potable reuse project that will meet the requirement of estuary diversion, putting the water to a reclamation use. It will also improve water quality in the city's water system, and it will improve our local water supply reliability. So that's one neat project that I get to work on here at the city. Next slide. Another project, the city has what's called a water neutral policy. These are policies that apply to new or intensified development to make sure they offset their demand to ensure that the city's water supply remains water neutral. I lay out here the options they can use to comply with the measure, and the fee proceeds collected are used to develop new water supplies such as that potable reuse project. I just want to highlight Caitlin and I had the same water law professor, Jennifer Harder, and she wrote a great article on this topic, and I got to help her with some of the research for it. And here's a link to it. So I thought it was really interesting. On day one here at the city, the first thing they had me work on was a water neutral policy. So it's funny how things like that can happen in your career. Next slide.
All right, so that finishes up our panelist presentation on their work experience. I'm going to move really quickly through these next few slides so that we can leave a little bit of time for Q&A. We're seeing all your questions come in through the chat and Q&A functions, so keep them coming if you have any questions. So this slide is just a resource for potential ideas for future careers. As it's listed out here, counsel for tribes or water attorneys can counsel tribes. They can work in-house for government agencies. They can work for NGOs, and they can work for private firms or in the academic or policy world. This slide here just has some resources for future education if you're interested in any of the items we talked about today. Click through the links if you're interested. And then ways to get involved. So if this program was interesting to you or you're interested in any of the organizations, you can join the sections once you've graduated and are admitted to the bar. You can attend webinar and in-person events like this. Yosemite Conference is obviously an annual event held every October. We have the Diversity Conference. This 101 series will hopefully become an annual event. And then we have the CYLA annual meeting. There's other ways to get involved too, through writing and educational opportunities. And please visit our websites for additional information. So I just wanted to quickly pass it back to Miles so we can talk about our Diversity and Inclusion Fellowship for law students.
Yes, thanks, Chris. So we have a summer program for law students. It's a Diversity and Inclusion Fellowship program. I was a fellow about 12 years ago, and I really enjoyed the experience. Here is the link to the website where you can learn more information to apply. The applications are now open for next summer, and they must be received by October 25th. So go ahead and take a look, and you do receive a stipend of $6,500 for the summer, an assignment of an 8 to 10 week internship, a mentor for the summer, as well as a scholarship to our Yosemite Conference. And thank you to all of our sponsors for this program. And if you want to donate, you can also find information on that on this link. Thanks, Chris.
All right, thanks, Miles. So we have a couple of questions in the chat and in the Q&A function. So I'm just going to start delegating them out. This one's for Caitlin. From Catherine Riley. The State Water Board has been curtailing water rights due to severe drought. Where those rights are dependent on use, do you view the board's curtailments as abrogating those rights? Seems like an interesting and thorny issue. I'd be very interested in hearing your thoughts. And I'll just jump in and start with, I think yesterday, the first lawsuit was filed against the curtailment orders. So Catherine, you're hitting on emerging issues, but Caitlin, go ahead.
Yes, so just very quickly, that could be a whole 1 hour topic as well. So I might just make some general thoughts and then maybe direct you to some resources to learn more about the current drought and kind of the complex regulatory process there. So you definitely nailed it when you said thorny issue. As Chris mentioned, the first set of lawsuits on the recent curtailment order they were just filed. I believe it's Sacramento County. So I definitely do a little bit of reading there. I would just say generally the way that the situation is, the State Water Board looks at conditions and says, based on current conditions, drought conditions, there's more demand than supply. And in order to protect health, safety, the environment, we need to start curtailing diversions of water from the state projects and the Central Valley Project use. And it's also more broad this year with some other watersheds. But and then kind of the natural challenge, those curtailment orders do have a serious economic impact on many people throughout the state. So it is kind of a natural, people will start to maybe challenge the state board's authority or the context in which they ordered those curtailment orders. And we'll all get to watch that unfold in the next several months as this new litigation progresses. I know that the Water Education Foundation has a great resource page on this. I think there's even a drought tab. Also, Maven's Notebook, that's kind of where I know I turn to get my daily water news and stay apprised of things. So I would check those resources out to learn more because those articles will do it more justice than I can in a short amount of time.
Thanks, Caitlin. Staley, this one's for you from Kim. What about the rights of a waterway, such as a river, which is being mismanaged by a city, county, or the state? What can citizens do to protect the river?
I guess I would like to hear a little bit more in detail. So there is a whole issue on, rights of nature itself. So I'm not sure if that's what the question is getting to, but if a river is being polluted, then interested citizens, people who recreate in that river, could potentially file a citizen suit under the Clean Water Act. I'm not sure if I'm understanding the question quite right.
And Kim clarified, yes, rights of nature.
Okay. Yeah, I know that there have also been a bunch of articles written about that. So if you want to email me, I can direct you to some resources.
All right, so 1 minute left. Thanks everybody for attending. If you have any questions that we didn't get to, or maybe we can answer one last one, or Caitlin, I see you typing in response to Ashley's question. Okay, great. So if you have any other questions, feel free to email any of us. Our contact information is on this page. And again, thank you for your time and for attending and showing interest in our program.